Newsfile is your most authoritative news analysis show. Joining us now, Abdul Malik Kweku Bako, who is editor-in-chief of the New Crusading Guide newspaper. He's a regular panelist. Also in the studio is George Lo, who is MP for North Dai and Vice Chairman, Constitutional, Legal and Parliamentary Affairs Committee of Parliament. Gentlemen, good morning and welcome.
Good morning, sir.
Thank you very much. Now, if we may just proceed straight to the next matter, and I think we can deal with the questions of whether the November 7 date is set, and also about the smaller parties that risk ban by the 30th or 31st of May if they have not done what the EC requires of them. But before we do that, are you a public service worker and need a loan to meet a dire financial need? Here's some good news for you. Apply for a loan from Bank of Africa and you are sure of getting your loan approved within 48 hours. Enjoy up to 5 years to repay. Get a discount on fees and ultimately start repaying the loan after 3 months. Yes, that's some good news. Visit any Bank of Africa branch nationwide for further enquiries. Bank of Africa strong as a group and close as a partner. Are you an MTN postpaid subscriber? Have you ever run out of data in the middle of an important transaction? That must be terrible. You don't want that experience. There is good news for you. So you can easily top up your data and in 3 steps. Simply dial *138, *138 hash from your phone, select internet packs, data top up, and then choose your data option. Stay connected to your friends and family on the best data network in Ghana. Call 100 or your account manager for further details. MTN Business, welcome to the new world of business. And Star Assurance is 30 years. And throughout all of these 30 years, what they have done is to make you feel that the perils and the dangers that exist in this world don't exist at all. You have to work in for homeowners, contractors, all risk, fire and allied peril insurance policy. And Star will make you feel very good. Insure with Star Assurance today and be part of the smiling family. You can take a motor and travel policy with Star Assurance and they will make your journeys very comfortable. So let's go and let's celebrate 30 years of solid partnership. You can log on to starassurance.com or call them 030-224-0632. Prostacure Tea by Medimosis Prostate Center is a special formulated health drink that improves any urinary problem that you have as a man. Frequent urination during the day or night, delayed urination, straining during urination, whatever it is. As far as it concerns problem with urination, Prostacure from Medimosis Prostate Center is what you need. Prostacure Medimosis Center, you can find them at Adenta Barrier, Tema, J. Kojo, or Ahenema Kokoben Kumasi. You can call 020-81-40668 or 0244-068447. Thank you very much. And of course, you don't have to forget about the goodies that NIIT is rolling out for you. They have the best of products for you and they are your #1 choice in IT education. They've been doing that for 15 years in Ghana. And now they are giving you certificate and diploma courses in software engineering, Android programming, PHP, web development, Java programming, hardware and networking, Cisco, Oracle, and database, and a lot more. Their programs are relevant to the job market today, so don't be left out. Corporate institutions, they invite you to take advantage of their special corporate packages. Good news is that SHS and GHS candidates, NIT is offering 20% discount on selected programs. Be better prepared for the next level. For more information, you can visit their website, niitghana.com, or call them 028-9674-770. NIIT, bringing people and computers together successfully. Now, I think I'll start with you, George. The issue about the the smaller parties, and they being given the ultimatum of the 31st of May to make sure that they have offices in the districts as required by law, or they risk being banned. The EC obviously is putting itself again in the way of returning to the courts. That's what people are suggesting.
Good morning, Samson, and good morning to our cherished viewers. Good morning to my uncle, Tarzan, who I haven't seen in a while. And he's now busy with policy issues. You shouldn't worry, I'll join him soon. And then my good brother, Kweku, back home. Well, very basic. The question you asked is that the EC doing something wrong? I don't think so. I think that the EC has all the rights to ensure that the laws that back, or the mandate that it has, is carried out to the letter. Now, in applying for a certificate, you are required to send some statistics, regional addresses of regional executives, national executives, in the districts and all that. Then the law goes further to say that after some time, you are also required to show them.
I'll let you hear very soon Nana Konadu-Adjumani-Rawlings and her view that this law is not being interpreted the way the EC is doing it.
Now, the EC, the law says that now, after some time, go ahead and do what? Establish the various, and let's have it. Basic reason, if you sit back and you look at the law the way it is, initially you ask yourself, why are they not required to provide the offices at the point of registration? You haven't been given a certificate. So for how many good reasons are you going to set up offices? do you see the point? Yeah. So it is from when you have been given a certificate and been certified as a political party. Then the logical thing is that now you go and set up offices. And when you have done that, you are required to come back to the EC and tell the EC that, look, I have my offices in the required places. And therefore, if you are looking for me in any of these offices, this is where you can find that. And it is for many purposes. You are a lawyer. You know the essence of having a designated office. Processes, if you want...
No, but you said that you ought to be registered first.
That is...
Before that is required.
Good.
So can you explain this provision for me?
Yeah, okay.
Section 9 of the Political Parties Law. It says that the Commission shall not... register a political party under this act unless C, that party has branches in all the regions and is, in addition, organized in not less than two-thirds of the districts in each region.
Yeah. I am saying to you that, something. So if you go and organize offices across the country, and you go to the EC and he says that, look, I won't register you. What do you do? Haven't you wasted resources?
Okay.
That is why they are saying that. They've also given you time to provide this information. Okay. It's logical. It's a logical inference.
So that may take us back to the earlier provision I read in addition to that. Section 15.1.
Right.
15.1 says, within 90 days after the issue to it of a final certificate of registration, a political party shall furnish the Commission with details of the existence and location of its 1. National, 2. Regional, 3. District, and 4. Constituency offices.
So basically, that goes to strengthen my point. That it is only when, if you don't have a certificate, what business, you don't have a business certificate, what business do you have going to be setting up offices across? It doesn't make sense. I mean, if you ask me. So the law is good. The law is clear. And the EC is saying that, well, those of you who have not satisfied the subsequent rule of furnish us with the locations in your constituencies, in the districts and all that. Do so within this time, or I will consider that you haven't gone through the full expectation of the law.
Let's listen to Nana Konadu-Adjumani-Rawlings and what interpretation she feels, particularly in this modern era, we should be putting on this particular law.
Good.
But we didn't have offices in every corner that we had the movement. And we didn't have offices in every district. We had offices in all the regions, but not in the district. Even in the regions, some of them, you know, sometimes they would have an office, sometimes they close the office because they're busy in the field. So I totally agree with Dr. Jonah that we should discuss this seriously and get back to the EC, because I saw her on TV saying, I'm following the law, I don't care what anybody says. And you can't talk like that to a whole country. It's not wrong. It's not right. It's wrong. So I think that it's the work you do on the ground, not the offices that you show to show off with. So whether you have all the offices or points of meetings or something, I think we should discuss it fully, and then we take a suggestion which should be sent to her, because we are all being threatened, as Dr. Deli said. Everybody is being threatened that if by 31st May you don't have all your offices, she's going to make sure that you are banned. She's just a member of the commission, not the commission on its own.
All right, so Koku.
No, if you give me 1 minute.
1 minute?
Yeah. You see, Nana Kuredu has all the right to proffer the opinion that she proffered. I mean, nobody will arrest her, nobody will blame her. But the point is this, there are two things. Even the law, in recognition of the fact that it's an erroneous duty, it says 2/3. It didn't say every nook and cranny of the country. So, in actual fact, it is not different from what she is saying. But the law insists that it should have 2/3. Why 2/3? The whole point is it should be national in what? Character. And it's a constitutional provision.
Okay, thank you. Koku, what do you say?
Well. We've been here before, but we all are coerced, more or less, as a nation, and allow this thing to flow because of our commitment to, multi-partyism in a way. And in the early days, it wasn't easy. Any attempt to do so would have implied that you wanted to kill some parties. It was a young democracy, we were nurturing it. So I think there was a lot of space for this kind of
in Nana Kuredu's peculiar situation, the last time she attempted to register, it didn't work. File her nomination, it didn't work. This time she's successful at organizing. She's been endorsed. She's going again, and this is becoming the stumbling block. So she feels very personal about it.
Sure, I can appreciate her sentiments. Whether I agree or not is another matter. But the point really is that you see a combination of factors, including financial and logistical constraints, were the points that made all of us think that, look, let's hasten slowly in operationalizing the law in a very exact and, direct way. But let's go back to the legal regime, which you'll be referring to.
Right.
And I realize that you refer to Section 9.
Yes.
The relevant portion here for me is C, 9C. Yes. The party has branches in all the regions.
Yes. Yeah.
And is in addition organized in not less than 2/3 of the districts in each region. Organized.
Yes.
Organized. And not less than 2/3 of the districts in each region. Here we are not talking necessarily offices.
Right.
It's clear.
Organized.
Okay. Organized. I heard Tarzan, I'm sorry. No, I can call him Tarzan on this show. I think everybody agrees. Making that point. Yes. And so it's organized. Organization might not necessarily lead to a physical office being seen.
This is the rendition in the Constitution, Article 55.
Yes, so that's clear. But of course, you refer to Section 15.
Yes.
Which is critical.
Which I think must have eluded most of the people who have been discussing
let me
it.
Say that I haven't seen the text of the EC directive to the parties. So I'm not sure what exactly the EC was demanding of the parties relative to this legal regime we are referring to.
They had cause to hold a meeting and discuss it as smaller parties. It must be the case that by 31st, if you have not complied, you'll be struck out.
Yeah, but it would be good to see the text.
The EC, for now, has only called for them to make a financial declaration. It hasn't talked about offices here.
These are the parties, and they discussed this issue because it was important to them at a meeting and said they will need to organize themselves and take a statement to the commissioner. That's what they said.
Yeah, but if it's, then we have to be careful. That's why we need to find out what is it that the EC is demanding.
Okay.
For now, it's only asked for financial information. It doesn't ask to...
That's interesting.
All right.
No, but that's interesting.
Okay.
If that's the case, then we are actually discussing a different subject.
Yeah.
Well, these are the parties, and they were at a forum, and made this declaration that this is what they need and to submit to the EC because they are under threat. And you heard Nana Kunedu, you heard Bernard Mona and the others. So
yes, but
I want to believe that
is saying contradicts.
What I'm saying that the specific thing that has been demanded of parties, even though I have a moribund party, I have instruction from the EC that I must declare my financial statements. Nobody's talked about offices yet.
Okay.
But the law requires you to have offices.
But the EC's officers,
yeah,
one of them has also granted an interview and insisted that this is the law and they intend to implement it. I'll look for that particular
we need to have clarification of that. So we need to, because it will help.
Right.
Otherwise, we may be discussing something that is at this stage a non-issue.
Okay. So let's hear Kuku. Yes.
Yes.
I'll come to you.
Now there's section 50, which is provision of particulars of national, head or regional, district and constituency offices and officers. Of course, now one says within 90 days after the issue to aid of a final certificate of registration, a political party shall furnish the commission with details of the existence and location of its national, regional, district and constituency offices. So the element of office is brought in here, and for that matter, district is also emphasized in here. Now you go to section 3, section 15(3), and you read, it says where a political party refuses or neglects to comply with this section, or B, makes a statement in a matter submitted to the commission under this section which is false, or C, has refused, neglected or failed to establish or maintain a national office or to establish or maintain a regional office in every region, the commission may cancel the registration of that political party. I find it significant that district is removed from here.
Yeah.
I don't know, you are the lawyer. But you see, district is missing, perhaps consciously omitted. And this is the stage where you may trigger cancellation. That is in terms of sanctions. If the EC is going to follow the letter and spirit of this thing and enforce, it may lead to cancellation. Of course, that you are told that you can appeal to the Court of Appeal for redress. So I'm not a lawyer. I'm wondering why the conscious omission of district.
Is it not the case that this is the requirement, but the only time when you can be punished, when your registration can be cancelled, is when you have not provided for national and regional offices? Is that not the case?
You see, the whole point we must note there, if you read the law in totality, is that there's a conscious effort of savings, technically, so speaking. The effort is to ensure that you meet the law, but also not to be so stringent, so much so that, you know, some people will find it too difficult to...
Okay, I think the direct question from Kweku is is a party liable, is a party's registration liable to cancellation on the basis that it has not provided offices in the district?
I don't know. It doesn't support, but it will also depend on case-by-case basis, the extent to which, because the May is giving the EC some leverage.
Yes, I see
some discretion to see,
so that what that will mean is that even if you have failed to provide for national or regional, it may not even cancel your registration.
Yes, it may even actually prompt you to say that, look, you haven't met the law.
Okay.
Take
all right. I think it
is in that line that we are even talking about the 31st deadline.
Right.
If what you are saying has anything to go
let's go
that do it by this time, or else we will be.
Thank you.
So this may end up being much ado about nothing then.
Okay.
Because if at the end of the day, the EC may or may not, and then all this noise goes on, they sit down, they say, okay, proceed.
Yeah.
Especially when we are in an election season, you know, all those. So what's the big deal? Are we seeking to enforce the law? Or we are seeking to just play around with the law? Shadow boxing. Is that what we are doing? Because if we are seeking to enforce the law, then let the EC check these parties.
Okay.
Do you have the offices as stated here or not? If you don't have, apply the law. No. Otherwise,
what
are we doing here?
What do you think the parties should be doing? Because they say they are under threat.
No, I think what the parties should be doing.
We'll hear Mr. Kwesi Jonah on his take on this also. I'll play it to you shortly. Yeah.
You know, we are a nation of laws. We live by the rule of law. And, you know, at the time when this law was being made, I spoke vehemently against it and said that even in advanced democracies where they've got money, you know, they all have just about national head offices and nothing else. You know, they don't insist on this infrastructure. The organization is important. But I think what people should do is that if it's the law of the land, you don't go and say that somebody is in trying to enforce the law is being obnoxious. I think you should quietly go and plead with the person and say, come on, for the last 24 years it's been quietly unobserved. We've only got 6 months before the next election. You're going to have to get all of us to spend all of our money into this. Can we please agree that, you know, defer this implementation until January 2017, where you may apply the full sanctions? But to treat it as something that you are entitled to, as if the EC is snatching away something that you're entitled to.
Why should you go and plead when you feel strongly that the law is being wrongly applied? And perhaps
why is the law being wrongly applied?
There is a certain discrimination to target them for some whatever reason.
You have to be specific about where the law is being wrongly applied. And as I said to you, the only instruction that I know of that the EC has given to political parties to date is that submit your financial things. But if the law says have offices, you know, at the time, those who passed the law in '92 maybe had a motive for insisting on offices. When we are talking about people going to vote, etc., and the word organization. And I'm saying that don't insist that you will not obey the law. And don't insist that a person who is enforcing the law is necessarily being obnoxious. You know, you may go and plead with them or discuss with them, not in public. You know, there's too much of this thing of people making noise in public before they even go and talk to those they should talk to.
See, but
okay, let's hear Kwesi Jonah briefly, and then I'll come to you.
I have said that, first of all, it is not a very, very good step to take in an election year, because you cannot abolish the small parties without any challenge in court. Some of them will go to court. And when they do go to court, the EC will be distracted. The body that is organizing the election will also be moving in and out of court, trying to defend an action. So if I had my way, I would advise the EC, hold on. Whatever letters that you have sent to the parties, let us withdraw them, or let us suspend until after the election, then we can together discuss the best way forward.
Thank you very much. So you heard Mr. Kwesi Jonah there. He is with IDEC. Thank you very much. He's just joined us in the studio. Thank you for coming.
Welcome.
Right. And you had a point to make.
If we're to proceed on the premise that of what Tarzan is saying, to the effect that the whole thing is about financial reporting, then I'm asking whether that problem has to deal exclusively with the so-called smaller parties.
No.
I'm wondering, because I believe, for you know, the bigger parties too may have a problem there. If you go into the law, the Declaration of Assets and Expenditure by Parties, that is Section 13, 14, Declaration of Assets, Liabilities and Expenditure in relation to elections, then Section 21, Returns and Accounts of Political Parties. Are they all fully in compliance?
Yes, in fact, Occupy Ghana is on their backs on this enforcement of the political parties.
Okay, that's what I'm saying. That letter has gone to all political parties.
Interesting.
And I don't know what specific thing that the smaller parties are standing on.
Interesting.
Probably because they hear that the EC has gone to get a budget to inspect offices, They think
Yeah,
that
we need clarity on that, because that is quite interesting.
What is clarity?
The report, Doc, you were at this particular forum at which you gave the interview we just played.
Yeah.
The report that came out was that the Electoral Commission has warned that it will withdraw certificates of political parties without district offices by the end of May. Do you know if that is a direct instruction to the parties?
As a matter of fact, if you go straight by the letter that the EC sent to all parties, they don't mention. They don't mention withdrawal of
So who
certificates.
manufactured that?
They don't mention withdrawal of certificates and so on and so forth. All that
No,
they
but
say is
offices.
that they should comply
With the law.
Offices. They should comply with the law.
With the law.
By end of May.
don't mention
Otherwise,
offices.
they may. Now, this is the problem.
Interesting.
The problem is that this is not the first time this matter is coming up.
Sure.
Periodically, the EC has gone around inspecting offices, and the EC is, by law, expected to receive two kinds of reports, financial reports from the parties, after every election, how much money you spent and so on and so forth, every year, how much money you spent and so on. It just so turns out that those who are not able to comply with the so-called two-thirds of offices in the regions are the small parties. On the other hand, sometimes even some of the big parties are not able to comply with the accounting, financial one. Now, so the question, if we were to sanction, all that the EC says is they may sanction. They don't say you withdraw, they say they may sanction.
In fact, that's what the law also says.
Sanction they mean suspension or from one election or the other.
People's interpretation of the...
That is what the letter says. Now, let us assume that because almost all the small parties are not able, PPP is able to do that, and I understand APC has also just done that.
Yes, APC's leader, Sana Yarga, says those who are complaining are just lazy.
No, assuming all the small parties are not able to comply, therefore, we withdraw certificates. Even though that is not what it's saying. There's an ultimate penalty.
Interesting.
And then we come to the one on financial accounting. One of the big parties is not able to. How many parties do you have left? One. You see? So we should be, I agree entirely, enforcing the law, ensuring the rule of law is absolutely in consonance with democracy. There are practical reasons why you should tread a bit more cautiously. So all the parties are not able to comply with offices, you withdraw. One of the big parties is not able to comply with the one you withdraw. You have one party state.
So should the next elections be another grace period? Is that what you're suggesting?
No. Now the matter has come up very, very seriously. And all of us, including the small parties that are complaining, must get together and examine the law once again. To be honest with you, the law is very, very unrealistic. When we had only 110 districts, you started with 110 districts.
We have done 200.
They had to have just a 60-something offices. But we are chasing a moving target. We are now 216 districts. No one knows whether you hit 500 before 2020 elections. So we are chasing a moving target. They are constantly being called upon to establish more and more offices. Second, the historical reasons. If you check the law on opening offices in two-thirds of the districts, the idea behind it is perfect. It's like Kwame Nkrumah's Avoidance of Discrimination Act. That law was introduced to stop regional and ethnic parties from operating, religious parties.
Yes.
So they passed this law 1956. Any party that is based on one region, one religion, or one ethnic group cannot operate.
But it's not an office that would define that kind of thing.
No. Now we don't want to go back to that.
Okay.
So we think that opening offices everywhere. Opening offices everywhere.
I read some material and I thought that it was actually the EC speaking, but it's rather those who wrote the stories who had put in that the Electoral Commission has warned that it will withdraw.
They may apply.
I mean, may I suggest that, again, we are backing on the wrong door. The EC must, insofar as it runs elections, apply the laws that are in force. If we are looking for a remedy, Parliament, going along with Kwesi's thing to tread slowly, although 6 years of treading is not too slow. One of the first things that must be done in the next Parliament is for that Parliament to revisit that law and take away all those provisions.
Okay.
Because as long as it's there, any EC that wants its, I'm sorry.
Apply.
No. What I'm saying is that if you see, one of the things we do one of the things we say all the time is Parliament. We must understand it. Parliament doesn't get up in the morning and decides that we are taking away this law. The smaller parties can come together, sit with the EC, and or all political parties at IPAC can say, no, we need to amend this law. And then make a proposal to the Attorney General. And then the proper law will be brought before Parliament. Until it's brought to Parliament. Parliament doesn't so moto deal with all these things.
Well,
Parliament,
that's the process, but I'm saying that the law needs to be changed.
Yes, that I agree. But you see, the impression most people carry is that Parliament can just get up on its own and say, no, we are changing this law.
In the same way, the impression that people think the EC can do things on its own.
The next question is on the next issue. You are in Parliament, you are with the Constitutional Legal Affairs Committee, you are the Vice Chair. Are we voting in November, on November 7th?
Well, all things being equal, we will vote on November 7th.
Is this never equal?
But there are practical reasons why people are raising this issue.
Things are not equal, is that what you're saying?
Because as we sit today, I am not aware that the law has gone through both it's supposed to be gazetted two times plus some 10 days.
Virtually.
Yes.
The first one has been done.
The first one has been done. And then after 3 months, another one has to be done. Then after 10 days, it's brought to Parliament. I'm not aware that Mr. Speaker has received anything. Then after that, Mr. Speaker would cause the first reading to be done in Parliament. And then sent to the Council of State, who have 30 days within which to bring it back. Parliament is rising at the end of July. So that is a practical reason. We may have to recall Parliament.
Yeah.
But in all this, the most serious thing is that you require 2/3 majority to pass.
You need both sides of the House.
You need both sides of the House.
Yeah.
Look, 2/3 means 206 or so, or 207 members. NDC has about 148. If you add the independent, it still doesn't get the 2/3. Okay? So that is why some of us are saying that we do not mind. And I heard my senior brother talking about people's postures and things like that. Yes, I don't think that posture has anything to do with what we do on the floor of Parliament. But you see, that is the minority leader talking, the deputy minority talking. They keep the people into line. So if they choose to keep the people not to support it, we are in trouble. But I think that Parliament has always used the spirit of consensus building to arrive at most of our decisions. I believe that this is one case where generally we are all adding that 7th November works better than the December.
This is supposed to be a small amendment.
Very.
It's supposed to be maybe a one phrase or line amendment. Is that not the case?
Oh yeah, it's not a big amendment. With the proposal they brought, I chaired that meeting. So
the issue has to do so much with the length of the sentence.
Yeah, but the clause
has to be the procedures.
Okay.
And
the availability of the members.
It all has to do with the last minutism of Ghana. We've all agreed that, from CRC days, that this must change unanimously. The reform thing, I heard Kweku talking about it last week, reading the report. Why wasn't this amendment put before Parliament at the beginning of this year? Why are we doing it now?
If I remember correctly, it came from the EC to the House on quite early.
The EC doesn't draft laws.
No, because I chaired the meeting. I chaired the meeting that my chairman was. I chaired the meeting when the EC met us with Attorney General. That was just before we rose in the last.
Yeah.
Yes.
When was this?
Oh, that was about 4 months ago, 5 months ago. Before we just went on the last reset before this one.
But I'm just saying that
So what has to happen to make this a certainty?
What I'm saying is that as for all the other things, I'm sure that it will go through. I mean, the amendments, the gazetting will be done, the period will be respected, it will come to Parliament. In the event that it comes to Parliament when we are on recess, there's always the opportunity of an emergency recall, which if it becomes necessary, will happen. Council of State will work on it. I'm sure they'll bring it in good time.
It's expensive.
But yeah, this is national duty.
Okay.
We will come. But I am saying that for me, the most crucial thing that we must work at is the fact that you require 2/3 majority to pass it.
To be present in the House.
Yes. So that is it.
Do you need it now?
I really wonder what is happening to this country. The consensus is already there. Yes. Had been there for a long time now. The Constitutional Review Commission, if you look at its report, all the deliberations that went up and down, they came to this 7th November thing. as a proposal, of course, a recommendation. The Electoral Reform Committee that Afarijan set up, it was a EC committee. The NDC, the CPP, the NPP, all those parties, civil society groups, IDEC, IEA, and all the rest represented. I have a copy of the report here. Yes, I have the report here.
He was a member of that committee.
He was on it. And I have their report here. And beautiful consensus. So why should there be even a problem? A shadow of doubt that we may not be able to crystallize or mobilize a consensus in Parliament of all places.
Oh, Kweku.
No, I'm not.
He's making a very valid point. But I'm just saying that is the politics we find ourselves in. It's unfortunate. But if a side of the house decides that I'm not going to cooperate,
after having been part of the consensus,
it happens all the time.
This will be politics that
it happens all the time.
Why will any side of the house decide it will not cooperate?
They may have various reasons. They may not be reasons that we agree with.
That would be politics without integrity.
Yes, no, but already started. When you hear the deputy minority leader say
the last time we're involved in the discussion,
in the discussion, he says that look,
talking about somebody's
be very careful. We don't like the posture of the TC. If she doesn't change, she should know that we require this now. That is it. So it tells you that even if they decide that tomorrow I don't like Charlotte Osei's face because she says something we don't like, they could sabotage the system. But that is the reality.
I see. Interesting.
But that is not in the interest of the nation.
Let me share with you some of the messages that have come in, and this one is coming from Kobe Esmond Trey. He says, please inform Honorable Law that his interpretation of the law is a little out of touch with reality. The EC gives provisional licenses to newly formed parties, subject to them opening offices in 2/3 of the districts upon which they are granted permanent license. This should be the proper interpretation of the combined effect of the said provisions. Thereafter, the EC monitors continuous compliance with the law. Respectfully submitted. Okay, thank you for making that point. And then, okay. You are in a hurry to discuss corruption and other matters. We will get to those issues very soon. Berema Preko Nana Kofi says that, can the Electoral Commission cancel the registration of a political party if that party is unable to establish district and constituency offices, looking at the section 15, subsection 3C of the Political Parties Law? Okay. You may have paid attention also to Kweku's reference to the subsequent section that suggests that the cancellation may only be to the non-compliance, to the non-availability of national or regional office.
No, it's district and regional offices, right?
Yes, but where you are supposed to be the registration is supposed to be cancelled, the law says if you have not established national or regional offices. They seem to have left out the district in that regard. Frank Wiafe says the EC chair is either not, does not know what to do, or is being influenced by government, or just too incompetent to lead us into the general elections. She deserves whatever. Okay. I'll move on with that. Get specific with the issues that you want to address. Thank you for the messages that you are bringing it to us. I will look at them carefully and then share some of them also with you. There is this particular one that is to Dr. Reku Brobe, and I'd like to read that one quickly. It says that he find it a bit disturbing that Dr. Reku Brobe seemed to think that everything that the EC is doing is right, and yet he finds problem with all the parties. That cannot be. And this is coming from James Farron. He says, isn't it surprising that Dr. Brobe seems happy about all that the EC is doing? He rather blames Parliament and everybody, yet insists that the EC is independent. Thank you for your messages. Now, let's now move on to the next issue as far as the EC is concerned, and which is an issue that appears that to suggest that the EC may be back in the court. Will it anyway? The Supreme Court gave its judgment. The judgment is now being subjected to all sorts of interpretations, particularly on the disagreement about what exactly the court said about NHIS registrants in the 2012 elections. The victorious, so to speak, the plaintiffs seem to suggest that the ruling says, or the judgment says, that remove the names of those who registered with NHI cards. The EC says that is not our understanding, and it issued a statement to that effect. I'd like to start on that note with George. Do you agree with the EC's interpretation of the judgment? If you do, why? If you don't, tell us why.
You know, something I'm laughing. I'm laughing because I have read the judgment. In fact, this morning I reread it again.
Okay.
But the EC says that they understand it in a certain way.
Yes, they say.
And I cannot fault their understanding. That is the way they say they understand it. The judgment itself raises problems, and genuine problems for anybody who reads it.
You think so?
Because in one vein, it says something, and then another vein, it says another thing. And then when it comes to the orders that the court has given, they've given clear orders. Now, if the EC says they don't understand the orders, I don't know.
They have not said they don't understand.
They understand
so their interpretation, right, for them is that we do not have to delete names. Is that what they are saying?
We do not have to delete NHI card holders.
Fine.
Or registrants.
Good. I'm saying this from the perspective that, you know, when being a lawyer yourself, when you go to court, it doesn't matter really what the judges say or how they arrive at their decision. The only time it matters is when you decide to go on appeal. But when orders have been given, those orders have become sacrosanct until they are overturned. You understand? That's what I'm saying. Is it the reasoning leading to the order? Because in one vein, it looks to me as though the Supreme Court is, particularly in 7, is saying that delete, and then they put clean in inverted color.
So this is let me read. And then let me read the orders as in they put.
Yes,
as quoted by the EC.
The EC.
The EC sent this release and said the Electoral Commission and its legal advisors have carefully studied the recent judgment of the Supreme Court on May 5, 2016, in respect of the case of Abu Ramadan and Evans Nemako versus the Electoral Commission and the Attorney General. The Commission confirms that it accepts the ruling of the Supreme Court, which ordered that A, the Electoral Commission takes steps immediately to delete, or as is popularly known, clean the register, the current register of voters to comply with the provisions of the 1992 Constitution and accept applicable laws of Ghana. B, any person whose name is deleted from the register of voters by the Electoral Commission pursuant to Order A above be given the opportunity to register under the law. The Commission is of the view that the directives of the Apex Court are clear and emphasize the processes already laid down in the law for cleaning the voters' register. The Supreme Court was of the view that these processes are ample and sufficient to remove the names of ineligible and diseased persons from the register. Ineligible and diseased persons. The Supreme Court essentially held as follows. So this is their interpretation. That the Electoral Commission has a duty to compile a credible register and in so doing must act within the remit of the Constitution and applicable law. 2, that the existing law has made ample and sufficient provisions for ineligible names to be deleted during the exhibition of the provisional register but such deletions must be in accordance with applicable law. 3, for persons who registered with NHIA cards, such registrations were lawful at the time of registration, and the subsequent declaration of unconstitutionality in the earlier Abu Ramadan case does not automatically render them void. Such a position, according to the Supreme Court, would have the effect of disenfranchising persons affected. Such registrations should only be deleted by means of processes established under the law. The process of validation proposed by the petitioners is without statutory authority and is carrying out its functions. The Electoral Commission cannot employ non-statutory remedies. Further, the Supreme Court unanimously rejected the following reliefs requested by the petitioners: that the current register of voters is unconstitutional, null and void, and so on and so forth. So they just proceed and they say the processes is going on, and they want all others to help them.
My whole point. You see, when a Supreme Court has made these statements about the constitutionality or otherwise of a process, and has actually gone on to say that statutory means should be the recognized means of attaining the efficiency of the EC's work. Why do you go to the end and now give specific orders and say that delete? That is where I have a problem. I would have thought that you leave the EC to use the law as it is to delete. That would have resolved everybody's problem. It is the definite orders that have been given at the end that, for me, creates a problem. If definite orders are not
those orders do not mention NHIA specifically.
No, but you see, listen. I think that you will have it, but you also listen to the orders, and for
the
me,
orders
see,
are the Electoral Commission takes immediate steps immediately to delete or, as is popularly known, clean the current register of voters to comply with the provisions of the 1992 Constitution and applicable laws of Ghana. Yeah. That any person whose name is deleted from the register of voters by the Electoral Commission, as above, be given the opportunity to register. Under
whose
the law.
Name should be deleted?
I think it's not more the question of whose name, but the process by which you must delete.
But I'm saying that
is the issue.
Somebody.
No, I'm saying no.
If you are talking about the process, somebody's name must be deleted. Clearly, they've stated that people who are dead should have their. But people who are dead cannot have a challenge where you have to reinstate them. So if you are talking about not only deleting but also reinstating people who, if you read the judgment, who purport to have used energy, and they clearly said that yes, it is void or voidable, if you want to put it there. It's voidable, but not void.
That's what they said.
Yes.
That's not automatically.
So my understanding is that if you can identify that, Kweku Baku used NHIA card to register. If you can identify, during the exhibition, give him the chance to say that, well, I use NHIA, but I'm Ghanaian because I have a valid driving license. Okay? So he goes and shows his valid driving license. Then he's authenticated. Let me put it that way. That is how I would want to interpret it. It doesn't mean that it doesn't make the whole register. It doesn't mean that it should be cancelled. But it says use the legal means available to you. And the EC says that that's what we are going to do during the exhibition. So I think that the position now is that parties should, as it were, engage the EC to find out that collectively what is the best procedure that we can use in the light of the Supreme Court ruling to clean the register. That is where we should be. As for court, I know people are saying EC should go to court for a clarity, or the applicant should go to court. As for court going, I've always said that it is open to anybody. You can go to court for anything. So if anybody chooses to go to court, that will be their business. But I think that it is clear, and I agree, that at the time that anybody used NHIA card, it wasn't illegal. It wasn't unconstitutional. In actual fact, the applicable law at the time
do you hear the EC to say
allowed it
that to say ultimately that the court made needless orders? Is that what you hear them to say in their statement?
Well, what I hear them rather say is that the courts, the orders that
are accepting, you have no option. So
the court made orders that they understand to mean a certain thing.
The court has made orders,
yes,
which confirm what we are already doing.
That is what they are saying.
So were the orders necessary? Were they needful in any way? Because if they are already doing them and they went to court,
well, but you know that court can either reject or affirm what is happening. So if the court affirmed what we are doing, it means that they are only saying that we believe we are doing the right thing.
Okay, thank you. Quickly, let's hear you.
If the EC is categorical that they are not, the NHIS cards are not part of what are to be deleted, then they are not in compliance with the order. And I will explain why. I'm coming from the street corner anyway. I'm not a lawyer. See, the issues, they set out issues to be dealt with.
9 of them also.
Yes. Issue 7, for me, it's of critical importance here. And if you permit me, I would want to read a relevant portion.
Go ahead.
It says, then there is the issue 7, which raises the question whether the plaintiffs before us have proved the extent to which the register of voters is accurate.
Which page are you reading now?
Page 31.
31, thank you.
For it to be unreasonable within the meaning of Article 45A of the Constitution. The said article deals with the obligation of the Electoral Commission to compile the register of voters for use in public elections and referenda in the country. In considering the point which arises under this issue, we wish to take judicial notice of the fact that since the delivery of judgment in the Abu Ramadan case, Supra, that's the first one, names that were entered on the register with the utilization of cards during the registration exercise conducted under the repealed legislation, CI 72, I emphasize here, have not been deleted from the register of voters. The continued presence of such names being derived from a constitutionally declared wrong offers sufficient proof of the extent of the inaccuracy of the current register of voters and can therefore be said to be unreasonable. We are of the opinion that any public document required to be compiled under statutory authority that contains entries which are instances of non-compliance with mandatory constitutional provisions, as is the case with the current register of voters, has the attribute of unreasonableness. The presumption being that the law is intended to be reasonable. Any act that is derived from unconstitutionality must be deemed unreasonable. Accordingly, issue 7 is answered in the affirmative. Now, this captures the point that the cards, just to be also brief, with how they describe it, makes the current register unreasonable and inaccurate and not credible. And the others point to the fact that make this register reasonably accurate and credible. That's what the others are saying. Make this register reasonably accurate, credible, and with accuracy. That's what the others are saying.
You said issue 7 was answered in the affirmative.
Yes.
This is issue 7 out of the 9 issues that were set down. Issue 7 is whether plaintiffs have proved the extent to which the register of voters is inaccurate as for it to be unreasonable within the meaning of Article 42A of the 1992 Constitution. And the Supreme Court says, yes, they have proven this.
Yes. Now, then when they proceeded to give their reliefs, address that, this is what they said. The result is that we proceed to grant the following reliefs. 1, that upon a true and proper interpretation of Article 45A of the Constitution, the mandate of the Electoral Commission to compile the register of voters implies a duty to compile a reasonably accurate and credible register. Reasonably accurate and credible register. The Supreme Court has voted for the need for that. 2, a declaration that the current register of voters, which contains the name of persons who have not established qualification to be registered is not reasonably accurate or credible. Recall the earlier point about cards and the fact that they said in spite of the repeal of CI 72, those names remain on the register. For that matter, it makes the register unreasonably, that's not reasonably accurate and credible.
Yes.
Then it comes to 3, a declaration that the current register of voters, which contains the names of persons who are deceased, is not reasonably accurate and credible. Reliefs 4, A and B are dismissed in their entirety. In exercise of the power conferred on us under Article 2.2 of the Constitution, we make the following orders. That the Electoral Commission takes steps immediately to delete, or as popularly known, clean the current register of voters to comply with the provisions of the 1992 Constitution and applicable laws of Ghana. One of the applicable laws, my opinion, is CI 91. And there, the cards are removed. That any person whose name is deleted from the register of voters by the Electoral Commission, pursuant to Order A, about be given the opportunity to register under the law. Well, I didn't go far in education. But look, the dead cannot be given the chance to register. The minor cannot be given the chance because he would have committed even a crime. Yeah. So that could lead to some consequences. Then, which other? The foreigner. Also, it was a crime. You could even be dealt with and jailed.
One has been arrested.
So who is left? Which category of ineligibles is left? By the trust of this ruling, it is the cards that is left. So the question now is how?
Correct.
To go about it.
Yeah, that's what I'm saying.
Yeah, but if you suggest that the cards are not you, I mean the EC's position apparently to me is that the cards, no way. As if that's a no-go area. That's wrong. Yeah. That's not in consonance with this judgment. So now we should be discussing how. Now, the election, the exhibition process, is it effective remedy to identify those who use cards? Truly? You see, my view is this. We should do the right thing. We should find means. Sitting here, I don't have the technical or professional competence. Let me be honest with you. I'm inadequate when it comes to the specifics. But I'm saying that the end result is that we need a reasonably accurate and credible register. If you go to an election with a register that is not reasonably accurate and credible, as required by this ruling, you may be sowing the seeds for certain litigation that could affect the integrity of the declaration.
Interesting there. Your views and comments are still welcome here, and we'll share them with the rest of the world, particularly post them on the Facebook wall, and we will share them with everybody else. Now, I want to come to you, Dr. Rekubrobe, and what you had already written and said that the Supreme Court needed to clarify. The EC says, as far as it understands the judgment, there's no need for clarity. Yeah. The Supreme Court has literally endorsed what we are already doing. So we'll continue with that.
Well, see, there were two parties to the litigation. Mm-hmm. One, I mean, the one who's been giving the order sees it one way. The one who took the action sees it another way. And, you know, it was interesting that immediately the EC read its judgment, the whole media...
The Supreme Court read its judgment.
The Supreme Court said, this is what has been ordered. And I said, no, let's wait, because there seems to be, I don't read in this order any specific thing to say automatically take out or whatever it is. And
some lawyers or legal scholars will tell you that the orders form an integral part of the judgment.
I know, I read it.
Judgment forms an integral part of the
point about it is that since...
So you don't take the orders alone, you don't isolate them.
Since lawyers are arguing about it, it lacks clarity.
Of course.
The apex court of this land, its main duty is to interpret for us what our constitution is trying to say and the laws are trying to say. As you say in Twi or Hinikasa Asa. So whatever it says must be seen to be the same by everybody. Now here's a case where the plaintiff and the one who is being ordered and myriads of legal people are giving different interpretations. And that for me as a civilian, I'm not going to pronounce what I think. That's why I said process. The process can mean that the EC has accepted to delete the national health insurance cards, but it doesn't accept that it must do it blanket and automatically. You understand? Because it has no law to empower it to take out people's names.
From what Kweku read, the portion Kweku read, does it help to change your position a bit in what you are saying? There may not be clarity on the call or the order to delete, or an order to delete NHI cadres. Now, if you may want to read that together with this particular portion, and that is page 21 of the judgment. Page 21 of the judgment, they refer to the 2014 case. They say, in our view, following the previous decision of this court in the Abu Ramadan case, by which the use of the cards for registration was declared unconstitutional, the continued presence of names on the register that derive their identification from the said cards renders the register not reasonably accurate or credible. Then they proceed to say, in coming to this view of the matter, we are not disregarding the report of the panel, Justice Crabb's panel, which is part of the processes before us in these proceedings as Exhibit Abu 6, that the register of voters is bloated, a fact which is not controverted by the defendants. We are in a great difficulty, however, agreeing with the plaintiffs that by virtue only of the said infraction, the entire register has the attribute of unconstitutionality. The said registrations were conducted under CI 72, which was the applicable legislation under which eligible citizens were registered before the 2012 elections. I'm ending on this. As the registrations were made under a law that was then in force, they were made in good faith, and the subsequent declaration of the unconstitutionality of the use of the cards, the EC refers to this portion, of the use of the cards, should not automatically render them void. But this is where the EC stops. Should the EC stop at this point, where the court said, the legitimate way of treating them is to have them deleted by means of processes established under the law?
You see, I don't think my view matters in this. The fact that people are arguing about it, that's why I said it lacks clarity. And
no, but when you hear Kweku and when you hear this portion read to you, do you find clarity or you don't?
I don't, because I still don't find clarity between it and the orders. That's the point I'm making. The orders talk about applicable law. Well, CI 72 was applicable law at the time, and then
But
it was taken away.
Now, applicable
No,
law.
no, see,
They said do in accordance with applicable law. So CI 72 doesn't come in.
No, but the point I'm making that is process. They may agree to the deletion.
Right.
But some people think deletion means take everybody out and then give them the chance to reinsert.
No,
They are saying,
take the cars out.
they are saying that is not.
Not everybody.
Well, I mean, the other side, take them out, take the cars out, NHI's card, and let them. And they are saying, well, the process that we have does not proceed along those lines.
But if
wait,
go down.
So the issue is that, I respect the views of legal authorities by, yesterday I was listening to Sankoma, and he says that both parties should go and seek clarification. That's not different from what I said. I really don't think that we can decide, here's somebody who's been ordered to do something. They say, I see it one way. And the person who took the case to court says, I see it a different way. Nothing that we say is really going to decide the matter. And so I think both parties, as I said yesterday, go back to the court and say, please clarify the issue for us. Your decision on 7, is it directly related to the order as we gave, or what are you saying? Because there's enough confusion, in my view. You see, the Supreme Court decision is supposed to be clear and to everybody without any kind of ambiguity about it. If lawyers start to argue about it, we are talking ambiguity. It's important for all of our sakes, that our appearance is made and this is clarified.
Dr. Jonah.
Yeah, thank you so very much. I've been listening to Wisdom Kuku and Tazan have been, this is the position of the EC has always been that I don't agree with the EC that the holders of NHIA cards are not to be deleted. But for them, their interpretation has always been in accordance with the applicable laws. Right. And they say that the applicable laws allow me to do that only during the exhibition. But that is where the danger lies. Now, by the time we exhibit the provisional register, we are so very close to election time. The order says, when you delete, give them the opportunity to register.
Right. That's the end of this.
By the time if you are going to wait, and they say that within the law, only the exhibition gives me the power to delete names. Now, if we are going to go very strictly by this interpretation, by the time when do you do the exhibition? Approximately 2 months after the last registration. We would be so dangerously close to election time that even the continuous registration window, which will now be available, may not be enough to enable the very many people who registered with that card to register before election. So, in accordance, anytime they say in accordance with applicable law, they are saying that the existing law CI 91 allows us to claim during the exhibition. You get the point?
Yes, but
if we are going to wait,
there are others who also argue that if they are saying it is the exhibition process they have to use,
yes,
they must go back to the Abu Ramadan first case in 2014, and they made a submission, and this is what the court said, and I'm reading the earlier case, this part of it. The judgment as delivered by the Chief Justice was this: the plaintiffs argue that unlike the documents listed under Regulation 1, Subregulation 3, A, B, and C, respectively, blah, 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 it comes to say the health ID card does not distinguish a Ghanaian. No, I'm reading from the wrong point. It's paragraph 21. Curiously, this one too is in that particular paragraph. That the argument that the first steps outlined in Subregulation 3 of CI 72, which enjoins the presentation of an identification document, is only for the purpose of inclusion of an applicant's name in the provisional list of the voters' register, and the further argument that in any event, a process for challenging or complaints about the inclusion of unqualified individuals under Regulation 16 of CI 72, the court said, is dangerous and must be rejected. No amount of rationalization can justify this contention. Plainly, in our view, that challenge mechanism is the final window of opportunity for removing the names of those unscrupulous individuals who, in spite of the necessary due diligence, all possible human care and attention, have nonetheless managed to slip through the net, beat the system, so to speak, and fraudulently managed to have their names included as qualified individuals. Then they end on this note by saying, given the imperfections of human systems, it is for the ultimate purpose of achieving a more credible and reliable register that avenues are subsequently created for cleaning the provisional registers. As the expression has come to be known in our jurisdiction, but provisional registers are expected, for all purposes, to be prepared in full compliance with legal requirements at any given time. An unhealthy reliance on the challenge and complaint tier is bound to generate chaos, confusion, and anarchy at registration and polling centers. It would indeed be palpably wrong to view the registration process as a license for either throwing overboard the constitutional restrictions or handling the registration process itself haphazardly, then it goes to say it dignifies mediocrity, which certainly is not a value which we in this court should endorse nor promote. So some say, if they are saying this is the system they are going to use, they should go back to the first case in which the court said, this is an invitation to dignify mediocrity. And that the challenge process should not be an avenue to use to do the deleting and cleaning. Because this challenge process exists, and yet fraudulent people have gone in.
No. I don't think the court fully understood. When a challenge is mounted at the registration center, there are further steps. The system is not as bad as the court say. There is a district registration review committee.
Right.
Subsequent to that, there is a district registration review committee. Sometimes a magistrate can be included on,
yes.
on the panel to scrutinize all those challenges that have been mounted. And nobody's name gets deleted from the register without giving that person a hearing. The person will appear. And there have been very many cases where somebody who had challenges was subsequently exonerated and his name was entered into the
This is the process you have gone through.
Yes.
To procure the register we are talking about.
Yes.
This is the register that has been declared not to be reasonably accurate or credible. And this is the system that was used. The court is suggesting that.
No.
That
Don't forget, we are talking about the cards. The cards were not challenged at that time. We are talking about the cards. The holders of the cards were not challenged at that time. Don't forget.
But
that's not an issue.
The point is this. I also look at it from the holistic perspective. Look, we also must not proceed as though...
Can we take a break and return to take your point?
Okay, all right.
Please don't forget about it.
All right.
Thank you very much. We'll be right back.